In response to our Sabinus versus Peakmilk versus Gala story posted last week, most of you have asked that I answer this question. Would it make any difference that Sabi was yet to receive a trademark certificate? Comment Sabi's trademark certificate if you want me to answer this question. Here's my take on that. Trademark registration in Nigeria is done in phases, from the original availability or name search down to the application or filing, to the acknowledgement letter, acceptance letter, publication and opposition before the certificate. Going by our Trademarks Act 2004, particularly sections 3, 18, 19, and 22, one would say that the rights and benefits that comes with a trademark, including the right to an action in court against trademark infringement, can only be exercised by a trademark certificate holder. That's someone who holds a trademark certificate. However, the law is not cast on stones, and the law is what the judges, the court, say it is. In the celebrated and popular case of D&S Trading Company Limited versus Remio, the Court of Appeal stated that a trademark acceptance letter issued by the Trademarks Registry was sufficient to be relied on for trademark infringement claims in the absence of a trademark certificate. Like I earlier stated, there are different stages to trademark registration, and having applied for trademark registration and you've accepted acknowledgement letter, or you've been issued an acknowledgement letter, the next thing you would often be issued is an acceptance letter. What does acceptance letter mean? It means that the trademark registry had carried out preliminary research and seen or come to the conclusion that your proposed trademark does not infringe on any other existing registered trademark. Obviously, that is up until there is an opposition when the trademark has been published on the trademark journal. What this means is that once you have an acceptance letter, while you're waiting the trademark certificate to be issued to you, which in Nigeria, due to bureaucratic and I would say systematic failures, would take anywhere between 12 months and 36 months, if not more. Yeah. And imagine that you have applied for a trademark and you have your acceptance letter issued to you within a month. Yet you cannot make use of the acceptance letter because you are still waiting for the trademark certificate to be issued. And the trademark certificate is issued to you in 4 or 5 years' time, knowing that your trademark will lapse after 7 years. What becomes the essence of running to the trademarks registry to register or apply to register that trademark? So the Court of Appeal reasoned that once a trademark acceptance letter had been issued to the applicant, until there is an opposition to the trademark, that acceptance letter suffices for several applications. It suffices to make a case against potential or actual trademark infringers. And this judgment is not limited to what the Court of Appeal says. When you're applying for NAFDAC licensing in Nigeria and many other agencies and parastatals, when they ask for a trademark certification or they insist that your brand has been trademarked, an acceptance letter will usually suffice. Bringing this down to the Sabinus versus Peakmilk versus Gala case, one would say that if the court indeed entered judgment in the case, the probability is Sabinus will probably emerge winner if all of the elements constituting trademark infringement have been proved against Peakmilk. Sabi may not have to wait for 3, 4, 5 years to say my trademark had been infringed upon, because at that time, don't forget, in December 2021, he was issued an acceptance letter pending when that trademark will be published or posted, if any, and a certificate issued. So like I said, this is my take on if the non-issuance of a trademark certificate to Sabinus for the word mark or slogan something huge would have persuaded the court to enter judgment against him or otherwise. I remain Mr. Ujong, your startup, IP, and consumer protection lawyer.